Good afternoon, everybody. This is John Sweet from the Pennsylvania Utility Law Project. I wanted to note before we begin that today's PowerPoint has been uploaded to the Sketch app, along with a one-page USTRA explainer, a sample USTRA injunction, and a sheet on recommended reforms that we will be discussing, advocating for at local municipal utilities. Today's webinar, I'm going to begin by giving a brief COVID-related update and some background on unregulated utilities. Then Rob Ballinger is going to talk a little bit about setting rates and discounts. Then Dan will talk about fighting terminations and tenant protections, and he'll hand it back off to Rob to discuss homeowner issues, and then Dan's going to finish up with due process and appeals. So the COVID update and background on unregulated utilities. To start off, just to touch on regulated utilities briefly, the PUC's emergency moratorium on utility terminations is still currently in effect. We don't know for how long. It's come up for a vote at every public meeting over the past couple months. But as of today, the moratorium is still in place. We'll keep you updated on that. This, of course, does not mean that all households are connected. So the unregulated utilities that we'll be talking about today are not subject to PUC jurisdiction and are therefore not subject to the moratorium. Of course, no utilities were required to reconnect households, although many have, and they had been encouraged to do so. As far as PUC complaints, BCS is open and taking emergency related complaints, especially for houses that are off. But two things to note, which is that BCS is not taking unregulated utility off cases. They're referring them to 211, the Attorney General's Bureau of Consumer Protection, and the Office of Consumer Advocate, as well as the Small Business Advocate. And we just want to let you know that you can contact us right away if you are working with a client whose service is off and who's trying to file a complaint but possibly not getting a response from BCS. As far as the unregulated utilities, specifically municipal water authorities, their trade association, the Pennsylvania Municipal Authorities Association, has given non-binding guidance for them to not terminate and to restore service that has been off, as well as some other steps that they could take. However, they again are only a trade association. So while most authorities had initially followed that guidance, we are hearing more and more about municipal authorities that have already resumed terminations or are considering resuming terminations shortly. And so that's why we thought it'd be important to give a presentation on how to help address those situations. And I'm going to hand it off to Rob to talk briefly about what's going on at Philadelphia Water.
Thanks, John. Good afternoon, everyone. So in the city of Philadelphia, I work at Community Legal Services, and our water department has every month announced just before its moratorium is expected to expire that it will extend it again. So we may have more news in the coming days, but for now, the moratorium on shutoffs is scheduled to be lifted on October 1st. The city has made deliberate attempts to restore customers, and although it looks like a positive number, it's actually quite troubling that more than 15,000 customers who were shut off prior to our winter moratorium, which is the same period as the PUC's moratorium, were restored after March 14th or thereabouts, when the city decided it was going to proactively restore customers. So folks who had gone through the winter without service were restored thanks to thanks to the pandemic. So customers should call and request restoration if they're still off. The city is waiving late payment fees and suspending other types of collection activities. It's also suspended requiring recertification of income for our low-income programs, and low-income customers who are not enrolled should apply for the tiered assistance program to see if they can get a lower bill. Back to you, John.
All right, thanks, Rob. And now, so to give you a little background on why discussing municipal water and sewer is important. Water is becoming increasingly expensive. In the early stages of CAP programs and things like that, water was often overlooked because it was considered affordable. However, rates have begun to spike in the past decades because of aging infrastructure and the utilities needing to raise money to repair that infrastructure, which has been coupled by the influx of private utilities buying up municipal authorities, which is kind of a double-edged sword. On one hand, they do bring PUC protections and often some customer assistance programs with them. However, the flip side of that is they're often accompanied by huge rate spikes where rates can double or triple in the years after the purchase. There's three main types of unregulated utilities in Pennsylvania. The most common is the municipal authorities. They are specifically exempted from PUC jurisdiction under the Municipal Authorities Act. As I discussed earlier, they do have a trade association that does have some influence there, the Pennsylvania Municipal Authorities Association. However, the main venue, the exclusive jurisdiction, would be the Court of Common Pleas to challenge anything related to rates or service. Municipal corporations such as Philadelphia Water Department and like Bethlehem Water, their city departments, and for those types of entities, if they do provide service outside their municipal boundary, they are subject to PUC jurisdiction for that portion of the service that's provided outside of the municipal boundary, whereas municipal authorities are not subject to PUC jurisdiction no matter how far they spread. And the third is co-ops, which we consider to be the wild, wild west. There's really very little regulatory oversight. And if you run into issues with co-ops, we recommend going to the Office of Attorney General's Consumer Protection Bureau, as they are still subject to unfair trade practices law and unfair debt collection practices. So unfair debt collections may come into play for unfair terminations there, but again, not much recourse in other venues. For customer unregulated versus regulated utilities, regulated utilities typically are required to provide protections for vulnerable customers, such as medically vulnerable households and victims of domestic violence. There's also a PUC formal and informal complaint process, which the PUC also will force the utilities to enter into payment agreements, which are required by statute, which are tiered payment agreements. None of these protections apply to any unregulated utilities. And with that, I will hand it off to Rob to discuss setting rates and discounts.
Thanks very much. Let's go to the next slide. I don't want to get too deep into rate making or rate setting, but I think just kind of having a little bit of the lay of the land might help those who are interested and sort of tee this up, because I think one of the things we think about is using the rate setting process as a way to advocate for different programs and protections for our clients. But setting rates can be very complicated, right? But the basic and ideal notion, the sort of starting place for setting rates and charges, is determining what is the cost of service. And typically, utilities will hire a consultant to do a cost of service study. And then you take that overall cost of service and recognize that sort of each facet of the cost of providing utility service has its own sort of functional unit that drives it. So for example, some O&M costs, operating and maintenance costs, will be allocated to the function of treating water, like chemical costs, while some other costs might be associated with customer service, like billing and collections. So the costs of those different functions may be recovered through different types of rate structures, for example, a variable rate or a fixed charge. Let's go to the next slide, please. Thanks. So once you sort of have the overall picture of what the cost of service is, you can determine what a utility's revenue requirements are. And that is the amount of money that the utility needs to collect to meet the cost of service. So for example, this is a very short overview of what goes into the revenue requirements, but this is some of the standard items. You would see operating and maintenance expenses in all the various categories. You'd see the amount of the debt service, because a municipal utility usually funds a lot of its capital program by issuing bonds. And you would also see any coverage metrics it had to meet through revenues. So for example, if it had to obtain sufficient revenues to cover 1.2 times, which is the standard here in Philadelphia, its costs after operations, then that would be its coverage metric, and it may have to set revenue requirements higher just to meet the obligations it owes to its bondholders. There then could be some cash financed capital, so-called PAYGO capital, and you would see some indication of whether or not the utility is going to end up contributing to or subtracting from any reserve accounts that it may have. And finally, there would be some recognition of any other revenues. So for example, John talked earlier about utilities becoming subject to PUC jurisdiction if they provide service beyond their municipal bounds. So the city of Philadelphia, if it provided retail service outside of the city, that would be subject to PUC jurisdiction. Wholesale service, however, just providing the water without actually having the end user subject to an agreement with the utility, that would not be something that would be part of a PUC jurisdiction. So that might be a source of some other revenue. Add all that together and you have your revenue requirements. But because all of those things are typically determined based on a future budget and a forecast of what the utility will need, it's really hard to determine whether they're accurate at the time the utility is setting rates. So you also have to think about how you really test those assumptions, and we'll talk briefly about that. But one other note is that an issue that comes up here is if a utility needs a fixed amount of money, it has to set rates to obtain a higher amount in recognition of the fact that some customers can't afford to pay. And I have an example on the next slide for that. Can we advance to the next slide? Thanks. Actually, it's 2 slides down. My apologies. We'll get to it in a minute. But when you're thinking about potentially challenging rate assumptions, because they are forward-looking, one thing you can look at is how past projections have worked out. And for example, here in Philadelphia, rates were set over a period of multiple years with the expectation that the city would spend down its reserves, but the opposite occurred. Its reserves kept getting higher and higher and higher every year while rates went up. And that was because the methodology was too conservative. It understated what the city would get from ratepayers, and it overstated what certain expenses would be, and we were able to identify some of those over time. Another thing to do is to find out really the source and basis for the numbers, and here again another example could be a projection of the future cost of electricity. And we had this in a case a couple of years back where the city was saying, oh, our electric costs are going to go up 5%. And we know that there wasn't a rate case for PECO, our electric utility, ongoing at that point in time. So the question is, what's the source of that 5%? Is it higher price electricity? Because if so, we'd like to see some evidence that you're going to have higher pricing. They were unable to produce that evidence, and they actually agreed to take that cost right out of the rate case. Finally, I think it's important to recognize that at least for a city department, like the water department in Philadelphia, they have a relationship with other departments in the city. And so they're providing services back and forth to one another. It's important to make sure that those services and the cost of those services are really accurately represented and reflected in the cost of service study. Otherwise, you could have the streets department really benefiting from some of the repaving work or something like that, and without paying for the cost of some of those services that the water department would provide, and vice versa. Let's go to the next slide. So I mentioned earlier, and I'm going to go to the middle of the slide here, this example that you may set rates as a municipal utility with the expectation that some folks aren't going to be able to pay their bills, or that there will be a lag in collections. And so I'm not going to go in depth into the example here, but I think what this shows is that if you disregard low-income customers' needs and you just simply look at your revenue requirements and how you're collecting and determine rates on a uniform basis, what you're actually doing is you're collecting on what would otherwise be the subsidy to the low-income customer by raising everyone's rates, which is sort of illogical. So the purpose for me for a customer assistance program is to provide a bill that someone can afford by recognizing that instead of having a lower collection rate, you'll collect lower amounts from low-income customers and so have to raise everyone else's rates. You provide a program that provides the benefit of a cheaper rate to the low-income customer, which recognizes then an expense that you recover through rates and charges. That way you avoid sending higher and higher bills to poor people and getting a lower and lower return on those bills over time. Instead, you build a program with the explicit purpose to take the inability to pay and turn it into an expense that is passed on to other customers that helps low-income customers make affordable bill payments. Let's go to the next slide. This is just an overview slide of some of the various types of program benefits that a low-income program can provide. And I think this is largely sort of recognizing the PUC guidance and what is sort of out there among all utilities. So there's various ways to discount a bill to a customer to give them something that is affordable. And what is affordable is really sort of a policy level determination. A typical customer, an average sort of median income customer, may pay between 2 to 3% of their monthly income for water and wastewater services combined. For a low-income customer, in my view, 2 to 4% is an appropriate target. And the UN standard, what the UN has said is appropriate for low-income customers, is not to exceed 3% of income. It's common for a low-income program to also help customers deal with their debt, because debt is really the opposite impact of having an affordable bill. If you can't afford to pay your bill, you accumulate debt. And the utility needs to deal with that debt in one way or another. But a program that can use the debt and forgiveness of debt as an incentive to get payments from a customer is likely more likely to succeed over time. There's also hardship funds and other types of grants that can help customers, and municipal utilities like PUC regulated utilities often have usage reduction programs too. Next slide, please. So I know we have a lot of subject matter here, so I don't want to go through this too much. I would just note that these are some of the basic terms of some of the programs. The Water Department and the Pittsburgh Water and Sewer Authority. The Water Department has a straight percentage of income payment plan for customers between 0 and 150% of federal poverty. It targets 2, 2.5, or 3% at each tier, respectively. And it then provides 4% of household income agreement for customers who are between 150 and 250% of federal poverty. And finally, there are payment agreements that are fixed into the program for customers who don't have a special hardship, which really recognize that at 4% of even a low-income customer's household income, between 150 and 250% of federal poverty, that's probably more than the cost of an average monthly bill under our current rates. We do have arrears forgiveness finally in Philadelphia, starting with bill payments in the next month, October. Customers will be able to start earning toward elimination of their debt, which will occur after the 24th payment. We have some other programs, the Senior Citizen Discount. We have Homeowners Emergency Loan Program, which provides money for repairs up front, which is then repaid over 60 months with no interest. We are replacing lead lines if they're connected to mains that are already subject to be replaced. When those mains are replaced, customers get a free new copper water service line. And we do also have hardship fund grants up to $3,000 per customer. And John, do you want to tag in for Pittsburgh?
Yes, I just wanted to touch briefly on PWSA's program. So this program, it should be noted, was introduced, their bill discount program was introduced before they came under PUC jurisdiction. So this could be held as almost an example of a unregulated utility implementing a bill discount program. I won't get into details of the program other than to show that it does have a bill discount and a hardship fund element. They also have a voluntary winter moratorium, and that the Allegheny County Sanitary Authority, which handles much of their wastewater, has a separate program for PWSA customers to be eligible for. And it should be noted that there are significant changes coming to the PWSA program. We recently intervened in their most recent base rate case on behalf of Pittsburgh United, and we're able to achieve some significant reforms through a settlement. However, the details of the settlement are currently confidential, so we'll have more details to be made available once that becomes public. And then also just to note that Aqua Pennsylvania and Pennsylvania American Water also each have programs. Just to contrast these from the regulated electric and gas programs, which are considered to be mandatory comprehensive programs where they have bill discounts and arrearage forgiveness and hardship funds as all complementary programs. The regulated water utilities have more of a spotty approach. So whereas Aqua Pennsylvania offers arrearage forgiveness as part of their Helping Hand program, Pennsylvania American Water does not. But whereas Pennsylvania American Water offers a bill discount program as part of their Help to Others program, Aqua does not have that. However, both utilities have water conservation programs and hardship grants, and we are currently advocating heavily with both of those utilities to implement comprehensive programs and hope to achieve that in the near future. And I'll hand it back to Rob to talk about funding sources.
I'm not going to spend a whole lot of time here. I think from the previous slides, my preference is to go right down to the bottom here at rates to provide a real fixed source of funding that's predictable for customers and predictable for the needs of the community served. But there are other ways that programs are funded, and certain types of programs may be funded differently. But some of the utilities may have fundraising events or use bill inserts to try to get customers to opt into paying a little bit more to help those less able to afford their bills. There are potential sources of grant funding that can be utilized to offset the costs of low-income programs, and it's not uncommon in the context of a case or proceeding to consider whether an additional contribution should be made to benefit low-income customers arising out of litigation that may have affected them in the past. Let's go to the next slide.
Rob, we have a question here, if that's okay.
Sure.
Why are the reforms to help customers confidential if they're reforms which we would need to know if we're going to try to help our clients?
I would just guess for John that the settlement has not been approved and they're not in place yet, and they're probably still negotiating an overall settlement. But I'll ask John to answer that since he's a party to that proceeding.
Yeah, that's correct. So the parties have agreed to the settlement. It hasn't been approved by the PUC. It's therefore considered confidential and can't be shared until the PUC approves it.
Okay, so hopefully once approved, all of that information is not only going to be available from John, but be publicly available to anyone and everyone who is concerned. So just a few ideas on the ways that we might strategize to have a municipal utility or a municipal authority do something different. At the end of the day, they are subject to, or at least portions of them have obligations, their boards and their departmental heads to make decisions in the light of day, right? So maybe we want to start attending those or sending clients to attend those types of meetings and provide some information about what's necessary, what is lacking in terms of the need for customers with low income to maintain service. There's also direct ways to potentially reach out to a city or county solicitor and explain what affordable utility service and affordable water service looks like, and how there are other things going on. There are successful programs out there, and I can share information. I know John can share information, but we do get the kind of data that's necessary to make the case for these programs and the benefits that they provide in keeping customers on and enabling them to really manage their indebtedness. I think one of the things from my perspective that's really vital is to challenge rate increases, because you have that ability, no matter what type of utility it is. All utilities, regulated or unregulated, are subject to the constitutionally based just and reasonable standard. And with that, there is a recognition in federal case law that there's nothing that prohibits customers from raising customer service issues. We don't have an obligation to pay without a reciprocal obligation of the utility to provide reasonable service. So if meeting the needs of low-income customers is something that we really should prioritize, then that's really an important thing to bring up in the context of a rate case. If some of that sounds like lobbying and restricted activity, Pulp and certainly CLS is welcome to discuss that with anyone and try to help in any way we can with resources, or just, perhaps, as John suggested here at the bottom, acting as an intermediary. Turn it over to Dan for tenants and termination protections.
Yeah, the good stuff. All right, so hopefully everyone who is a legal aid attorney and handles utility shutoffs is aware of USTRA, and we're going to talk mostly about that. But just for a general broad overview, you're going to have three general categories for when a municipal water authority can shut off your water. The main one is, of course, non-payment of the water bill or non-payment of the wastewater bill, sewage, because you can't shut off sewage. So you have to shut off the water if you don't pay your sewage bill. And then there's, of course, tampering with the meter or with the water connection system. And then one last one that's kind of a little trickier is when there's a leak or an issue on the property and the owner or resident doesn't address that issue, then they can shut off the water. And that's a little trickier because, what exactly is the evidence and what is the level of competence that you have to apply as the owner or responsible party to try to stop that for your water from being shut off. So going back up to the non-payment issue, that's really the main focus of everyone's efforts today. And you have ways to stop that. Not when you can't pay. If you're lucky enough to have a discount program, you can utilize that. Generally, if you're not known as a historical or habitual non-payer, you can try to negotiate payment agreements with the authority staff. And of course, you can reach out for charitable assistance through local agencies. I always recommend that people call 211 as sort of the clearinghouse in their area for what's available for utility assistance. All right, next slide, please. And this is just a nice little chart of, what is required for before the municipal authority can terminate service. So if you're talking about water and you're the property owner, there's really not much that governs, statutory wise in Pennsylvania that governs how municipal authority can go about shutting off your water. Some municipal authorities will follow the guidance that's out there, from the PUC that applies to those regulated utilities. And then, of course, there's some constitutional requirements, which we'll get into at the end of this presentation, but very little statutory authority. And so you're going to be looking at the rules and regulations created by that particular authority. If you're a tenant in a building with the water being shut off, then that is when the Utility Service Tenants' Rights Act, USTRA, comes into play, and we'll get into detail about those requirements in the next few slides. Moving over to the sewer side of things, again, you have the division between tenant-occupied properties and owner-occupied properties. On the owner-occupied side, you have the Water Services Act, which provides general notice requirements and posting requirements of that notice before the wastewater authority can go to the water authority, or sometimes to the same place, and ask for termination of the water. If you're a tenant, you also get those notice provisions from the Water Services Act. And just to note here, the Water Services Act is a little tricky in its naming because it deals with wastewater, sewage, but it relates to the sewage authority's ability to shut off your water, or contact the water authority and demand shut off of the water if sewage isn't paid. I actually had a solicitor for a municipal sewer authority tell me once that the act didn't apply because it's called the Water Services Act. And I thought, oh, that's being a lawyer 101. Read the act, because when you read it, it's clear that it has to do with shutting someone's water off when you're a sewer municipal authority. So anyways, if the bill isn't paid to the property for sewage and it's tenant occupied, not only do they get the Water Services Act notice, but then it kicks back over to the USTRA rights that tenants get before termination of their water service. All right, next slide, please.
Dan, if I could just interrupt quick. This is Kelly. I'm going to launch the first of the CLE question polls. Please respond, attorneys, for CLE credit. Thanks, Dan. You can continue. Sorry about that.
Okay, no problem. Move this poll out of my field of view. If I can. All right, back to the slides. So it's interesting, and people should understand that there are two different statutes that apply to tenant-occupied properties that are having their utilities disconnected. One deals with what we're talking about today, municipal authorities shutting off the water or whatever utility is provided by the authority. And the other deals with regulated utilities, oftentimes your gas and electric, or your Pennsylvania American Water, that kind of thing. So privately owned utilities. They're very similar statutes, but there are some slight differences in language, which leaves it open to perhaps a slightly different interpretation. USTRA, the one we're talking about today that deals with municipal authority terminations, is the most clear in terms of its application to tenants, and that's the one we're going to detail going forward. Next slide, please. Get that next slide. There we go. All right, so what are the rights under USTRA? So if a utility company makes a decision to terminate service, essentially they have to make a determination as to whether the property is reasonably likely to be tenant occupied or not. And if it's reasonably likely to be tenant occupied, then they have to go through the procedure outlined in USTRA. And that procedure is going to apply to all right. So that's the obligation on the side of the utility company. In terms of the occupant being qualified for those rights, what you're looking at is, are they a tenant, and are they responsible for the water or not? And responsible for the water needs to be defined a little more specifically here in this context. Essentially, with USTRA, is the tenant the ratepayer? Is their name on the bill? If their name is not on the bill, they're not the ratepayer, then the requirements of USTRA and the rights provided for the tenant apply. So let's just break that down with an example. You have a written lease with your landlord, and the lease says you pay the landlord $100 each month for water. So under the terms of that lease, the tenant is responsible for water, but the tenant is paying that bill to the landlord. The tenant is not putting the bill in their name and getting direct billing from the municipal authority. So they would be entitled to the rights under USTRA. Now that would still be true even if the municipal authority has a policy where a tenant can receive the bills. We know it's a big problem that landlords will keep the bill in their name, and the lease will require the tenant to pay the landlord for the water usage, but then the tenant never knows what is the amount being paid. So in some circumstances, or some municipal authorities will allow the tenant, sometimes for a small fee, to request bills to be directly sent to them. But in my opinion, that's not making the tenant the ratepayer, the direct ratepayer. And so USTRA would still apply. I'll note that there might be some debate as to whether the statute applying to tenants' rights for regulated utilities would apply in that situation, but we're not going to get into that debate today. So for USTRA, it's very clean, it's very clear. If the tenant is not the ratepayer, then the protections, tenant protections apply. Okay, next slide, please. So again, going back to the utilities responsibility, if they determine that the property is reasonably likely to be occupied, and there's various ways that they do that, I'll say sadly that most of them don't do a very good job of making that determination or putting very much effort into that determination. But if that is true, then they're required to notify the landlord with a 37-day notice that they're terminating water, which is a notice we probably don't see very often in our practice, but essentially tells the landlord, we're going to shut your water off. We think it's tenant occupied. Tell us all the names of the tenants. And the landlord has 7 days to either stop the termination by paying off the bill or provide the information requested. And then if the bill hasn't been paid, the municipal authority can send a 30-day notice to the tenants, to the actual property, notifying the tenants of the pending termination in 30 days. Now, what's very important, and this is the key to USTRA, is that the tenants, when they receive that 30-day notice, have the right to maintain the utility service if they pay for the last 30 days usage. And they can, so in other words, they can step into the shoes of the ratepayer and maintain service by paying the last 30 days usage. And that continues into the future if the landlord doesn't step up and pay for the bill going forward. The tenants can continue to pay and keep water on while they occupy the property. I have to slow down here a little bit, because when I say last 30 days usage, the statute doesn't use that exact language. You can see it written here on the slide. The bill of the landlord ratepayer for the 30-day period. And so to me, that's clear. That's how much water, say, in a water situation was used in the last 30 days, and how much is one billed typically for that amount of usage. It does not mean the full bill, which is usually several months of back bill before the termination begins. What I find is that municipal authorities routinely ignore that language and cite in their notice, their 30-day notice to tenants, that the tenants have to pay the full amount. And that is something that needs to be challenged. Paying the full amount of what's due is often well beyond the ability of the tenant or tenants. And so that is one of the most critical aspects of enforcing a tenant's rights under USTRA, is making sure that the amount they have to pay as tenants to continue service is actually the last 30 days usage and not a larger amount. So make sure that you're reviewing that amount, that you're contacting the authority to ask them how they calculated that, or provide you with the past billing. I think is the most effective way, is just to ask for the past bills for the last 6 months or so. That should show you average usage, and it should show you how, whether or not the amount on the notice is actually calculated based on the usage. This can get very complicated in jurisdictions where the authority does not check the meter regularly and does a lot of estimating of the bills. So that leaves up that leaves a lot up in the air for the attorney to sort out and try to get the best amount for the tenant to have to pay. Now, the tenant has until the end of those 30 days to come up with the payment and pay that off. And that goes for single-family occupied dwellings as well as multifamily or mobile home parks. That is, it becomes much trickier when a multifamily apartment complex has to address this issue where they have to pay the bill for the full apartment building. But that's how it's done. So there has to be quite a bit of contribution from, collective action from everyone who lives in the property under that 1 meter to come together and pay the bill. They have 30 days to do it. All right, next slide, please. All right, so a few key protections in the statute. One, the tenant who pays this to keep water on has the right to reduce from their rent bill what they paid for the water. That's directly in the statute, so that should help you out in litigating against the landlord. There's also anti-retaliation provision. The landlord can't retaliate against the tenants for exercising their rights. There's no waiver. You can't waive this right in the lease. So pretty strong protections for the tenants. Now, one other thing I'll note is that this doesn't only apply to terminations where the landlord hasn't paid the bill. It also applies when the landlord wants to take the bill out of their own name or turn the water off themselves, which we see often, right? The landlord is going to do a constructive eviction by calling up the water company and saying, turn off the water to my property. And if the property is reasonably likely to be tenant occupied, the authority has the requirement to, before shutting off the water at the voluntary request of the property owner, to send out a 30-day notice. And the tenant has the right to continue service, even when the owner is asking for the service to be discontinued. So that's a big, important protection to stop the landlord from constructively evicting the tenants. And not a lot of the authorities are going to quite understand that. And again, it goes back to a lot of the authorities not doing a very good job of determining reasonably likely to be occupied. So that brings us to the other issue. If the tenant doesn't get this notice, tenant's calling you because they've got a 10-day notice or their water has actually been shut off. If they were not given the proper USTRA protections, that 30-day notice and the right to pay, then what the municipal authority should be doing in that situation, once they learn that the tenant is living there, is to turn the service back on and to start the process from the beginning with that original 30-day notice to the tenant, as opposed to either saying, well, it's off, so I'm not going to do anything, or, well, we'll turn it back on if your tenant pays the 30-day usage amount. Now, it should be all the way back to the 30-day notice that they missed, that they should, so they should turn service back on and provide the tenant with the 30-day notice. And that's critical to give the tenant time to come up with the money. All right, next slide. So we sort of covered part of this slide, and I'll just point out that often, landlords will just take action themselves, and that's not really the topic of this training, but that is just a straight up constructive eviction where you're going to hold the landlord responsible. But it's always good to call the water authority to double check that they weren't the ones who turned it off based on a voluntary termination. All right, next slide. Okay, and I sort of already touched on this as well. The Water Services Act, you have the site there. Again, that is the protection for people who are not, who can't afford to pay the sewer bill, and thus the water is going to be shut off. And interestingly enough, there is more notice requirement stated in the statutory required notice before termination. There's also one very important provision that I think some of us will find very surprising, and that is that if the ratepayer, the tenant, the occupant, whoever's going to be affected by the water shutoff, believes that it's being shut off incorrectly, wants to challenge the decision by the sewer authority to shut off the water, then they can do that. And the Water Services Act specifically says that once that happens, once the tenant files an affidavit in good faith saying they dispute this termination, then the water can't be shut off until it's been judicially determined. And that's really an interesting legal term that has not been very well defined, but seems pretty plain to me that it requires there to be either consent or an actual judicial action to get approval to move forward. Okay, next slide.
Dan, we have a few questions. Did you want to take them now or wait?
Well, I know we're low on time, so I'll just point out that that under USTRA there is a private right of action. This is probably limited to injunctive relief. So we have in the materials a sample equity complaint and motion for special injunctive relief. That's the main way that you enforce this rule against utility companies or municipal authorities that don't want to comply with it or disagree with you on the interpretation of the language. Okay, now I'll take questions.
Okay, first question is, does the tenant have to pay to get the water turned back on?
So that, well, if the water gets turned off and they were given the proper 30-day notice, then the tenant does have to pay. They have to pay the last 30 days usage to get it back on. So in one sense, I earlier said that the tenants have 30 days to make the payment. That's to keep the water on. Once the water is shut off, then the tenant still can get the water returned, turned back on, but they have to pay the 30 days usage to do that.
Okay, next question. What if the tenant has an oral lease? What are the best practices to force the service provider to work with the tenant if we don't have a written lease to prove Austra's application?
Well, I'm not sure what the best practices are. In Pittsburgh, we attempted to develop an affidavit to that effect with the Pittsburgh Water and Sewer Authority. If you don't, have one gigantic authority that you're dealing with all the time, if you're dealing with lots of little ones, or if you don't have that relationship, then perhaps your office can draft an affidavit. There is no requirement that the lease be in writing, although you will often get that pushback that they want various documentation, including a written lease, before they will accept the tenant as being a tenant. So that's going to, unfortunately, that's going to be a big issue to be litigated, a big reason why you're going to have to go into court. But to preempt having to go into court, if you don't have good documentation, like other bills that the tenant pays there, ID, things like that, then maybe an affidavit and bring in your notary to have it notarized, make it look nice and official for them, would be my suggestion. Rob, did you have anything to add to that?
No, I mean, I tried to sort of deal with a couple of these as they came in, Dan, because you were on a roll with your presentation. But I mean, in my view, an oral lease is enforceable in Pennsylvania, and USTRA doesn't distinguish between an oral lease and a written lease. So the key is to get that notice, to get that 30-day notice, and then if the utility is refusing to work with someone who's claiming to be a tenant, well, then I think you can either go through an agency dispute process, which we could talk about in a little bit, or I think you then can marshal that additional evidence, whether it's rent receipts, or some correspondence, or something like that, to prove the tenant is in fact a tenant. But an oral lease is enforceable in PA. So if you can get records to show, the tax bill for this property is going to the landlord, or the registered owner is an LLC. I mean, some of these things are so easy to show that it's reasonably likely to be tenant occupied. That's the key to me to getting the tenant protected under this statute.
Okay, the next question. If tenant assumes responsibility for future bills, are they eligible for customer savings programs even if the bill is not in their name?
Rob, maybe that one's for you and John.
Yeah, I'm gonna have to say no. In the unlikely event that you run into an unregulated utility that has a savings program, it's highly unlikely that they would ever let a non-customer tenant that didn't have the bill in their name.
Yeah.
In the program.
Some may not even allow tenants to become customers, but here in Philadelphia, you have to become a customer. And sometimes that even requires your landlord to provide written consent as a tenant for you to get the water bill in your name.
Yeah, remember the big difference between unregulated and regulated. Unregulated are lienable. So that's why there's so many issues with the landlord keeping the bill in their name, but charging the tenant separately, and why USTRA is so important.
That's all the questions we have right now.
Okay, well, the last thing I'll say about USTRA is always remember the logic when you're litigating this. The utility is not losing any more money. They're going to scream bloody murder that they didn't get paid, and shutting off someone's water is the best way to collect on owed debts. But if USTRA is applied correctly, they don't lose any money. And that needs to be made clear to the judge so that, the sympathies switch to your client.
It's a really good point, and not to take the other side, because I don't represent landlords, but we will talk a little bit about liens in this context. So let's go to the next slide, and we'll try to zip through this really quickly. I think some folks are probably familiar with this, that unpaid municipal water bills, water and sewer bills can be liened. They are municipal claims under state law. There's a 3-year statute of limitations, but it's sort of meaningless for the most part, because even a lost lien can be revived anytime. Unless the property has been transferred, and it uses the word purchaser, which has a common law definition I won't get into. But it can still attach even if someone's obtained a new mortgage or refinance. It just can't take priority. So an imperfect lien exists even before the lien is perfected by docketing. Let's go to the next slide. Some ways to deal with a lien, and I'm going to go in order from well, no particular order. The first one is a bad idea, probably. There are cases that have struck off insufficient liens based on the lien itself described something that was insufficient. And I give you an example there. One of the best ways to deal with liens is let's get some more customer assistance programs that help people eliminate their debt, and that'll eliminate a lien, right, once the underlying debt is satisfied. In the context of a mortgage foreclosure, also, I mean, there are much more qualified people to talk about bankruptcy than me, but perhaps bankruptcy is an option to force a repayment right. The last is to file a notice of stare fascis. And let's go to the next slide, because I have some caution for us all to think about that. So stare fascis is how the utility turns its lien into a judgment on the property. And the owner of the property can start that process by filing a notice, and then the utility has to issue the writ within 15 days, and then the owner has to raise their affidavit of defense, and any defenses they don't raise are waived. The writ itself constitutes prima facie evidence of the facts, so you really have to specifically deny. And the court's going to determine how much of the lien is admitted. If there are material facts in dispute, they can be tried by jury. I suggest looking for defects in municipal lien practices more broadly before bringing a stare fascis. And I think there are possibilities that that's happening based on what I've seen anyway in Philadelphia. But here's the cautionary tale. Let's go to the next slide. So if successful, the municipality issues the writ, and the judge says, judgment for the municipality. The judgment, you now have an executable judgment. And also, by simply proceeding with stare fascis, you're going to get the municipality's lawyers involved, and their attorney's fees can be added to the claim, meaning added to the lien, meaning added to the judgment. So you can end up getting your client in the worst position. And I have here a motion that PGW filed in a case here in Philadelphia where they sought not only a determination that the lien itself was valid and validly imposed, they sought approval in that same context to go ahead and just sell the property and execute. So you want to look at what the lawyers for your municipality are doing in the context of stare fascis a little bit more carefully before gambling on that 15-day turnaround. Next slide. Let's keep going for a minute here. Next slide. So some other thoughts before we get to, we're almost out of time here. Dan's going to talk about federal due process. Just realize you have local agency law here. Under the Pennsylvania Constitution, a local agency adjudication is appealable, whether it's a denial of service, a denial of an application. You can appeal those types of things to the common pleas court. And that's a right guaranteed under the Pennsylvania Constitution. So there's a whole Pennsylvania constitutional framework for appealing a municipality's determination regarding your client's rights to water, right? Let's skip down and give Dan a minute on federal due process.
Sorry, if I can just interrupt, I have to get the last poll
Sure.
in before the hour ends, but I'm happy to keep the webinar open for you guys to go on and get in whatever you need. So please respond to the CLE poll box attorneys requesting CLE credit. And Rob, please continue.
I'm gonna let Dan jump in on
Thanks.
the federal stuff.
Yeah, I'm back at it. I'll be real quick, everyone. I know time is limited. The federal claims are interesting to supplement, I think, your USTR rights for tenants and the administrative rights for ratepayers in general. What I'll point out is that utility, access to utilities like water does create a property interest. And so, constitutional rights come into play if that is being deprived. And the main one that comes to mind is procedural due process. That requires that there be some sort of regulation standard that applies to everyone as to how you're going to be charged, who's going to be terminated, maybe even to who gets a payment plan or not. It has to be standard, can't be arbitrary, ad hoc, can't be just because Sally doesn't like, Jimmy who hasn't paid his water, things like that. Then there has to be a procedure for disputing a denial of service or a termination of service. You have to have an opportunity to challenge that process. And then finally, you have to have notice of the opportunity to challenge it. And I think that even though this is a constitutional concept that's been around since the 70s, it's not very well known or applied in a lot of the smaller municipal authorities. As John pointed out at the beginning of the slide, there's lots of them in Pennsylvania. And so that can be a possible additional claim or means to help someone who is being shut off and is not getting the attention of the municipal authority. Of course, I'll point out that those can be difficult claims to bring. So you might want to get some backup either from CLS or CJP or PULP in handling one of those federal claims.
And I'll just add in, when we talk about a utility's decision to deny someone service, right? You go and you apply for service and they say no. If you have nowhere to go, that's an adjudication. The courts have looked at that and said that a final decision by a local agency that gives you nowhere to turn, right? That's something that under state law, and again, to Dan's point, if it determines that you are no longer entitled to service, could be a federal law issue. So there's a nesting of some of these claims that can happen both under state and federal laws, and really, it's your choices to forum. I think in some cases you might prefer being in the state courts. Some cases maybe not, but you'd have to go into common pleas, and so that may be interesting and different in different parts of the state. But Dan, that was great.
That's utilities in an hour.
We have a question, if that's okay.
Sure.
Is PWSA still considered a governmental entity?
John?
I mean, it is still considered a government entity. It's just that it's now regulated under the PUC, which makes it unique somewhat to other municipal authorities.
Yeah, and there's some interesting conflicts between the Municipal Authorities Act and the Public Utility Code that come into play with PWSA, where PWSA was brought under PUC jurisdiction by a specific statute, but it didn't address certain things like line extensions under the utility code. They're the responsibility of the utility. Under the Municipal Authorities Act, they're the responsibility of the customer, and just a couple other things like that, which have come up in the context of there's a rate case going on. There's also dual implementation proceedings going on that have to do with compliance with the Public Utility Code and how which statute trumps the other in where the actual statute that brought them under PUC jurisdiction is silent on the matter. So yeah, long answer for short question, but yeah, they're still a municipal authority.
I mean, as to the relationship between PWSA and its utility customers, I think functionally it's going to be the same as like PGW and its customers. PGW is a municipal entity, right? But the PUC regulation applies, broadly speaking, to all of those relationships between customers and the utility if the utility is under PUC jurisdiction. So there might be some stuff that falls out of that, John, but my assumption is that once those standards are sort of in place, the customer service standards they need to meet, that it's all going to be pretty clear that complaints against PWSA have to go to the PUC for utility service related issues.
Yeah, one more interesting issue there in which Robbie might have insight on, which is their ability to lien. So there's no ability to lien, which was specifically reserved for PGW, but they did not do that for PWSA.
Yeah, I think the Third Circuit has kind of made it pretty difficult to challenge municipalities' lien authority, but I think it is right, or even municipal authorities' lien authority. I think it is right that there was possibly some oversight in the legislative work there, because PGW's lien right was addressed not only when it became subject to PUC jurisdiction in the Competition Act, but again when Chapter 14 was passed. So PGW's lien authority has been really well preserved as its regulator has shifted. I think PWSA's potentially has not been as well preserved.
Anything else, guys? Okay, well, thank you for being with us today, our presenters, for sharing this information with us. Very helpful, and thanks everyone who joined us. And take care. Have a good rest of the day.
Thank you.
Thanks, everybody.
Thank you.